Hello, everyone, and welcome to this live episode of In Lay Terms. I'm your host, Payman Ascari, and I'm very pleased to announce a special guest today, Mr. Shawn Buckley of the National Citizens Inquiry. Welcome.
Glad to be here, Payman.
So, first things first, glad to have you on, and apologies to the audience. It's totally my fault that we're starting late. I had a stupid checkbox click that required Mr. Buckley to sign in, so that's on me, not on Mr. Buckley. Shawn, I thought maybe everybody knows who you are. You're sort of like a hero in the limited government freedom community. So why don't we start with if you could tell us about who Shawn Buckley is? Like, where were you born? Where were you raised? What have you seen change in Canada over the decades?
Yeah, well, first of all, I'll step down from the pedestal because none of us deserve to be on that. And, it's like I remember listening to one guy speak once, and he says, we think almost in pictures like a movie, right? And if you could display that onto a screen where everyone could see your real thoughts, you'd have to leave town. And so I, like everyone else, you know, are that way. And we all just find ourselves where we find ourselves, right? And this whole thing is going to work and change because we're all going to get involved. So I was born in Winnipeg. My father was in the Air Force, so we were living on the base, and then ended up moving to Edmonton as a baby and grew up in Saskatoon. Did my first degree there, a Bachelor of BA honors in history and poli-sci. I did not want to practice law or be a lawyer, but very interested in our Constitution and the social underpinnings of our Constitution, which are not very democratic at all, and have some assumptions about the common man that are not very flattering. So I wanted to become a political science professor. I'd been accepted to do a master's at University of Ottawa, great funding, the person I wanted to study under. And a professor who was a mentor at U of S sat me down and said, you're going to go and you're going to do your master's, and then you're going to go and do your PhD. And back then, this is like 1989 here. The baby boomers had all the professor jobs, and they weren't going anywhere for a long time. So they didn't want people to get PhDs in humanities because there were no jobs. So books were written on, the PhD trap. Like, it was hard to get one, but he says, you'll get one. Like, he says, you'll go through and you'll get your PhD. And then he said, and sorry, the sun's just coming up from a tree here. He said, what are you going to do then? He says, you're not going to get a job. You're white Anglo-Saxon male. And regardless of how I feel about affirmative action, the reality is I wouldn't get a job as a, political science or history professor. So I thought, well, heck, what am I going to do about that? And I thought, well, why don't I write the LSAT? So I wrote the December LSAT, which was already too late for law schools out in the East, thinking, well, I could go into law, do a master's in law, and then become a constitutional law professor. So, wrote the LSAT, went to law school, went to UVic, wonderful school. And, but the law schools were the very first university faculties that I was aware of where critical race theory had been introduced. So it was actually very interesting because I know nothing about this. And the first 2 weeks of law school was legal process, where literally the message to me was that as a white Anglo-Saxon male, I was responsible for, oppressing minorities throughout history. And like, wouldn't it be good if I, just like dug a hole and went and lived in it somewhere? It was really quite incredible. And again, regardless of what you think about that, it was divisive within the faculty. And so the law schools at that time, the faculties were very unhappy. And I thought, well, I don't want to be working in an environment where, people are at each other over political ideology that I don't want to be involved with arguing about. I'm just concerned about the problems with our Constitution and how it's not democratic. And that's what I want to. So at that time, so when I graduated from law school, I'd been in university for 10 years. I had a son, and I needed to work, and so I ended up becoming a lawyer. Never intending on becoming a lawyer, and definitely, but interest in Constitution. So I'm working on protecting our rights, which was funny because I don't like conflict. And I was a hired gun, and I tell you, in court, it's conflict and it's nasty, and so it's been a long career.
Shawn, one question springs to mind. You mentioned that the Constitution has some elements that are not democratic. Can you elaborate or give some examples?
Well, you see, Payman, I view a democracy as actually the people having some say in important decisions in their life. I mean, we think of Athens, which is, our first real case of a democracy, where literally they would get together and make decisions. Do we go to war with Sparta? Do we not go to war with Sparta? Type thing, right? And and they would debate things. Now, it was only the aristocracy that was able to vote in Athens. But still, that's what we think of a democracy as being able to have some say in important decisions affecting us. Isn't that what you think of as a democracy? Hey, wait. Hey, my vote counts. Okay, well, let's just take that at a riding level, Payman. So if there's some important issue for your riding, your MP isn't allowed to vote according to what the members in that MP's riding wants. The MP has to vote according to what the party whip says. And just so your viewers that aren't familiar, so every political party, let's just talk federally. So every political party in Parliament has what's called a party whip, and that person makes sure that all of the sitting MPs in that party understand the party's position and how they need to vote. So let's just use right now in the NHPPA, we've been heavily involved in trying to protect our access to natural health products. Well, every Liberal MP knows that the Canadian populace really wants this self-care framework to go away, but they can't stop what Health Canada is doing because the party whip is telling them, no, you have to support this. And same with the NDP. So if we had a democracy, how can we be in a system where even the majority of people within an MP's riding, because we elect them from riding, right? They're a local MP. They're the person we're supposed to go to have a voice. But we're in a system where the MP doesn't follow what the people who directly elected them want. I don't call that a democracy. So we have a parliamentary system. You will never actually get, well, I shouldn't say never. Sometimes we have a referendum on things, right? I've been involved in a couple of referendums. Now, one of them was in BC, they were bringing in the harmonized sales tax, and how they did it was politically unpopular, and so we had a referendum and actually made for businesses the wrong decision, but but just the way they'd gone about it politically. And when I say business, the wrong decision, you're still collecting sales tax from your customers. You're still collecting GST, but you can deduct the GST you spend as a business, but you can't deduct the PST you spend as a business. Like, you can't offset it. And under the HST, you're simplified. You're only doing one return, and you could also deduct the PST. So when I say it wasn't good for business, it wasn't, right? So, but in any event, that was actually followed. We had a referendum, but we had one in Kamloops over water meters. So there's a referendum. Do we get these smart meters or do we not? And overwhelmingly, people said, no, let's not get the smart meters. Well, we got the smart meters, right? Well, what's that? Like, so, but anyway, in my life, I've been involved in 2 referendums, and it's even hard to get a referendum. So do I have any direct say in how we're managed? No. So why do we call ourselves a democracy? And then most of us think that even the federal cabinet, our government, is in charge of executive decisions. Well, there's a reason why no one watching this video who's Canadian, who has gone through the public elementary school, who has gone through high school, the public high school system, who maybe even gotten a university degree or not, it doesn't matter. There's no one in your audience who has read the Canadian Constitution. And you would think that our most important law, the law that sorts out how we're governed, that we'd have to read it every year in school, that we would know it upside down and backwards. But see, they don't want us to read it. And there's good reasons why no one has read the Constitution that's watching this either live or will watch it afterwards, will actually have read the Constitution cover to cover or at all. Because we're not encouraged to read it. So, in the United States, the president is the head of the executive. Who's the head? Who's our chief executive in Canada, Payman?
I think this is a trick question. So I would say the prime minister and then the governor general and representative of the king.
Yeah, well, the king is our executive. No law that the act that the parliament passes becomes law until the king's representative signs it. And the king's representative doesn't have to sign it. So the king has a veto, basically a presidential veto. Our unelected king can veto any legislation. That our unelected king can dissolve parliament. Do you know what council runs the country? Who's the most powerful person in the country? It's not the prime minister. Do you know? It's the clerk of the Privy Council. What's the Privy Council payment?
I don't know.
Well, that's the King's Council that runs the country. Now, by convention, the federal cabinet is part of the Privy Council while they're in office. And then when they're out of office, they're not. But there are members of the Privy Council that don't change. Nobody knows this stuff. So it's just, that's the stuff that was interesting me. And, why I wanted to kind of become, educate people. And even the fact that our Constitution, our supreme document, they're just British statutes. The British Parliament could just change them. Well, how can it be in 2024 that the British Parliament could sit this week and change our Constitution? The King's Parliament in the United Kingdom.
I always found it funny that our Constitution is called an act, the British North America Act.
It's our Constitution is a whole bunch of acts. So that's the big one, which sets out division of powers and all of that. And the next big one is the Constitution Act of 1982. The Constitution Act of 1982, which is another statute of the British Parliament. Now, there's a whole litany of them. It's not just those two that form our Constitution, but they're all acts of the British Parliament. Now, in the Constitution Act of 1982, we did get these provisions that would allow us to amend that act ourselves. Now, it doesn't take away the British Parliament's ability to amend the act, but we could amend it ourselves, with the agreement of 50% of the population and 2/3 of the provinces, which is a formula that likely will never occur in our history.
Yeah, I've heard it's impossible to change anything. Mm-hmm. While I got here, before we get to the NCI, on the same topic, the 1982 changes that put the Supreme Court, it's my understanding that before 1982, the Supreme Court just checked to see if an act of parliament conflicted with a previous act of parliament. But after 1982, they became the final say on everything. Do you agree with that change in 82?
Hang on a second. So So the Supreme Court of Canada, so under the British North America Act, all superior courts they're called Section 96 courts because it's Section 96 that basically continues the superior courts from the UK within Canada and allows provinces to have superior courts. But we would have appeals to the Supreme Court of Canada, but you could then appeal from the Supreme Court of Canada to the British House of Lords. So we're a colony, remember? Our constitution are acts of the British Parliament. So so our earliest constitutional cases, they go beyond the Supreme Court of Canada to the British House of Lords. And the British House of Lords would then, they would be the final say. There would be no appeal after that. Now, you've caught me off guard on that. I mean, I want to say, actually, as of 1949, that's when we stopped having appeals to the British House of Lords, and our Supreme Court of Canada became the final appeal on constitutional matters. But it would never have been the case, like the Supreme Court of Canada was limited to just hearing kind of jurisdictional issues. I mean, you could appeal anything to the Supreme Court of Canada, civil law things, whatever, but they weren't the final arbiter, I don't think, until 1949. But you caught me off guard on that, so I could be wrong. But that's my final answer without checking.
I didn't know about the House of Lords, but my question was, before 1982, the Parliament was supreme. So the Supreme Court couldn't, the Parliament could do almost anything, and the Supreme Court had no say. But after 82, you had the Charter and you had rules established, unless you used the notwithstanding.
No. So we had this wonderful thing called the common law. So for example, let's just use freedom of expression. We had really strong freedom of expression in our common law that did bind government, right? So government couldn't step in and take away your freedom of expression. You had the common law right to freedom of expression that also bound the government. What happened in 1982 is we came up with this, let's put rights in our Constitution. And likely this was a political maneuver by Pierre Trudeau to sell the Constitution, right? Because his big thing was repatriate. And, we'll talk about how Pierre Trudeau in a moment basically is the one that moved us from a confederation into a unitary state. And I'll explain what all that is in a minute. But so we're putting these rights into a constitution and saying in the British Act, so with the Constitution Act of 1982, says, hey, this is the law. So Section 52 of that act, of the Constitution Act of 1982, says that the Constitution of Canada is the supreme law of Canada. And any law that is inconsistent with the Constitution is of no force and effect. So here, we've got this British statute saying this British statute, it's the supreme law of Canada. And so, and it includes our Charter of Rights and Freedoms. So what you're referring to is, hey, we've put in this Supreme Act, these rights, and so we can now use this act to say that, the government can't violate these rights. And so that gave us a new mechanism that we, call trying to enforce constitutional rights. But it doesn't mean that prior to that, the courts wouldn't hold the government to account on our common law rights. And, basically our charter rights, to most extents, we already had those rights under the common law. Right? So here we're experiencing in Alberta, really with our Bill of Rights fiasco, pretending that, we didn't have the right to refuse medical treatment before. So are you aware of what I'm talking about? So the Alberta government just recently, within the last month, amended our Bill of Rights supposedly to help us, but really they took rights away. So it was kind of like a bait and switch. And so what happened is there was a group in Alberta that was pushing, they were called the Black Hats, pushing to have a different Bill of Rights enacted. And the UPC at their convention apparently agreed to this. I wasn't at the convention, so I'm just relying on people. But rather than, use the bill that everyone thought they were going to, they're just making amendments to the existing Bill of Rights. And in Alberta, the idea had become popular, and we've all heard that, our government was supporting this, to add into our Bill of Rights the right to refuse medical treatment. Because in Alberta, a lot of people are upset about being pressured, or at least experiencing pressure, to take these COVID-19 injections. So why not put into the Bill of Rights, as if we needed in the Bill of Rights, the right to refuse medical treatment? Under the common law payment, we had the right to refuse medical treatment without exception, even if it would lead to our death. So there was no limitation on it. And then when we get to the Charter of Rights and Freedoms in 1982, the courts read into Section 7 of the Charter, that's the one that everyone has the right to life, liberty, and security of person. The courts have read into that section our common law right to refuse medical treatment. And there's not an exception on that. You have the right to refuse medical treatment, even if it'll kill you. So in my family, one of my grandmothers, who had been a nurse and understood medical things, came down with ovarian cancer. And she made the decision, I am refusing all treatment. Because she reasoned in her mind that was just going to lead to suffering. She didn't see it as saving her life. She saw it as just, what was left was just terrible suffering that she had witnessed as a nurse. And so she made the personal decision, no, I'm refusing all treatment. I mean, literally, she tried to die as quickly as she could. I mean, at the end, she even stopped eating. Like, I'm going out. Well, she was allowed to do that under our common law right to refuse medical treatment. Now, in Alberta, the Alberta government's just put into our Bill of Rights the right to refuse medical treatment. You would think, being that we already have the common law right to refuse medical treatment without any qualification, and we have the constitutional right to refuse medical treatment without any qualification, that if you were going to add that right to the Alberta Bill of Rights, you would just add that right without any qualification. But they add that right, and they add a qualification. And the qualification is unless it's likely, and in the medical context, what does likely mean? Like 1 in a million, 1 in 100,000? Like, what does likely mean? Unless it's likely that refusing the treatment could lead to substantial harm to yourself or to others. Oh, that sounds a little Orwellian, doesn't it? So that would mean that in Alberta, my grandmother would not have the right to refuse medical treatment. Oh, now that's interesting. That's interesting, isn't it? So you mean we would force her to go through chemotherapy that she was fairly convinced was just going to invariably just make her suffer more before she dies? Like, so that's interesting, isn't it? Now, that doesn't take away our common law right, and it doesn't take away our constitutional right. But what's going to happen, payment, is when somebody's trying to enforce their common law right or their constitutional rights, the Crown attorneys are going to say, in Alberta, they've got this limitation that if it's going to hurt the person, or it could, likely to lead to substantial harm, whatever these terms mean, then that person doesn't have that right. And now you've introduced into the judge's mind, into the court's mind, into the appeals court's mind, that this right can be limited. It will change the entire discourse, and that right will be gutted and become more meaningless than we experienced it to be during COVID. So the Alberta government has just done us all a grave disservice. And so everyone all excited, hey, we finally have the right to refuse treatment, when they've done the opposite. And I mean, I could go on, but before we segued, we were talking about how you were suggesting that we didn't have these rights to go against the government until we had the Constitution Act of 1980 true. And that just wasn't the case. We had rights that we could enforce against our government. We had common law rights, which, because we're in a system where rights aren't inherent, we had to have the courts say, no, these are limitations on governments. We call them rights under the common law, but it really just means it's where in history, in the history of the court decisions, that the courts have kind of drawn a line and say, no, Your Majesty, that's going a little too far, right? So let's not let you do that, so that, you know, we can keep the peace here. And so we call them rights. But it's important to understand that we're using the wrong term. It's really just a privilege that we're being allowed by Her Majesty's courts under the common law. And it's really a privilege. If you have the right payment, that means it can't be taken away. There's a line in the sand and it can't be taken away. Like, so, you know, when the first commandment says don't murder, well, that creates the right for you to live without somebody killing you. So we put penalties in place to try and discourage people from doing that, because we agree as a society, you have the right to life. So now in that case, that right comes from God. But, you know, for freedom of expression and things like that, if we don't have the right to express ourselves without, you know, without limitations that we agree to, then it's just a privilege being granted to us. And it's important to understand the difference between a right and a privilege. You see, the Americans, their Constitution, their rights come from God. They're not granted by the king or granted by an act of the UK Parliament. So their Constitution, you know, which isn't a British statute, they come from God, and that's tended to be, you know, a little more enduring. But if we have to rely on government to grant us rights, aren't we already in a philosophical problem here? Like, why do we need the Alberta Bill of Rights? Why do we need the Alberta government to grant us a right? Do you see the problem? Because then the message is that the legislature has the ability to then take away that right by changing the act. It's really a privilege they're granting us for a period of time, but it's not something inherent to ourselves. Why do we need the British Parliament to grant us constitutional rights by passing the Constitution Act of 1982, which includes our Charter of Rights and Freedoms? Why do we need, sorry, the sun's moving across. You might see me move around a bit. Why do we need the British Parliament to say that we have these rights for so long as they leave them in that act without changing them? So you mean we need that group of elected politicians at that moment to say that people in Canada have these rights for as long as the act says we do? Isn't that interesting?
Shawn, I have a question. I want to simplify it for people who maybe don't understand the law as well as you do. When you Google common law, it's almost synonymous with precedent law. But what is common law? Like, what is it based on? Is it based on the English Bill of Rights? Is it based on nothing?
No. So what happened is in, 1066, when William the Conqueror kind of conquered, he ended up setting up a court system. I mean, you got one thing that the force method of government imposes is laws, and then enforcing those laws. We have to have some mechanism for determining whether a law is followed or broken, and then imposing punishment to encourage others to impose the law. And then you also have to settle disputes, right? So, Payman, you and I are living beside each other, and I've got this nice cedar fence, and you tear it down in the middle of the night and put up one of those fluorescent orange snow fences. And now that's what I'm looking at, and looking at your ugly lawn furniture instead of my cedar fence. And well, how do we solve this? We got some mechanism. And what developed in, you know, in these courts started by William the Conqueror is the courts started going, oh, just wait a second. We had this case where, you know, a flock of ducks ran across the road and forced this horse and cart off, and he damaged this other person. And we decided it this way. And now we have a strikingly similar case, or at least the principles are the same. Oh, and that's how we dealt with it that way. And they started following how they had dealt with things before. And so then they developed principles. Hey, there's this legal principle and there's this legal principle. And some of it was just, you know, trial and error. Like, you know, just to use a criminal law context is, you know, back in the day, the penalty for a lot of crimes was death. And there were very practical reasons for that. It's like you didn't have, you know, a taxation structure and prisons and things like that. Like the society couldn't afford to imprison people for long periods of time. So, you know, if for a lot of crimes, and there's no way of rehabilitating people, really don't, just for society to protect themselves, you killed them. So, well, you know, some people can be dishonest and just lie that something happened. And so we learned, you know, maybe we need a couple of witnesses before we're going to put somebody to death. And, you know, maybe we shouldn't rely on confessions where a person was tortured. Because what would happen is we'd put people to death, and then the judges would learn they got it wrong. And they'd feel awful, right? Like, wait a second, we hung that guy. And he was innocent. And so they developed these really practical rules to protect us from getting it wrong because the stakes were so high. Well, it turned out even when the stakes are lower, they protected us wonderfully, and they would follow. So we have the, you know, we'd have this confessions rule that there can't be inducements and there can't be, you know, pressure and all of this. And it was just common sense. Now, what happened, and it was one of the biggest disservices that isn't spoken about, is we get this Charter of Rights and Freedoms in 1982. And the courts think that they're kids in a candy store. Hey, we get to create all this precedent. This is brand new. Like, it's us deciding what these rights are. And the judicial mindset changed. Like, we're now the philosopher kings. And from 1982 to today, we've literally thrown out about 1,200 years of wisdom that we accumulated with hard lessons. So the voluntary rule doesn't really apply the way it did, and the confessions rule didn't, and the needing to confirming, all of that's been thrown out. But like, I am convinced that never in history, the history of any, definitely Canada, will we be convicting so many people, you know, wrongly, because all of a sudden we're so much wiser, and trials now take 4 or 5 times longer because all of this is loosey-goosey. We don't follow these accumulated rules anymore, and it's a huge disservice that nobody anticipated when we create this constitution, and all of a sudden the court gets to rewrite everything. Like we've got, you know, an activist Supreme Court. And that in itself is fun, isn't it? These judges are appointed by the government, and they get to decide where the line is between the government and the people. Oh, and they're paid for by the government too. Oh yeah, no, but they're independent. It's all okay, Payman. It's perfectly okay. What could go wrong?
Shawn, a question. You mentioned 1982. The charter becomes, the supreme law of the land.
Mm-hmm.
Can you interpret that as like a reset? Everything before that is just wiped clean?
No, it's not. It's not. So the Constitution Act of 1982 does not take away our common law rights in any way. And that's clear in the Constitution, where the Constitution does not take away rights that we already had. But, you know, so I talked about we had strong freedom of expression. Well, Section 2B of our Charter of Rights and Freedom gives us freedom of expression. So now you're the Supreme Court of Canada or a lower court, but let's just stick with Supreme Court of Canada, and you have a case on freedom of expression. Well, you've got 1,200 years of case law on it. It's a pretty strong right. How are you going to make it stronger? So what you do is you say, well, 2B really, yeah, it's stronger because it's a constitutional right. It's our supreme law of Canada now. But you say, yeah, but it's really the same as our common law, right? You bring in all those principles. But we've got the bait and switch happening here. So, and I'm going to say this slowly, and I might say it a couple of times, because this is how the Charter of Rights and Freedoms took away our rights instead of giving us our rights. So here we have freedom of expression. Before 1982, read the case law, it's strong. We had freedom of expression because, in this interplay in the United Kingdom with tyrants and despots and this and that, and trying to create this elected autocracy system, this parliamentary system where parliaments, had some rights against the king and all of this, we learned that you go to bad places if people can't express themselves. And if you think long term, how is the society ever going to grow or change or get better or get worse? But how is it going to change if people can't express their ideas? So we had in the common law this wonderful protection of freedom of expression. And if we'd never gotten our Constitution, then we would just be arguing these principles where court case after court case after court case basically says, it's the bedrock of a liberal democracy. It's a bedrock of a healthy society. You let that go and you're in trouble. And there's no limitation. It's just a right. But along comes the Charter of Rights and Freedoms, and it gives us the right of freedom of expression in Section 2B. But we got this justification clause in Section 1. And so Section 1 of our Charter of Rights and Freedoms reads, the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it. And I wish it stopped there, Payman, then we'd be fine, right? So if it was the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, bang, if it ended there, we're fine, but it doesn't. Now it's got the subject. It has the justification clause. That's our mischief. Subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Now, that's a word salad, if I've ever seen one. But what basically it means is, oh yeah, you've got these rights that you had before. You have these rights that you had before, but now they're subject to the government saying, yeah, we violated your right. The courts found we violated your right, but we're justified in doing it. We had to. It gives them, before under the common law, you violated my freedom of expression. Court goes, heck yeah, you did. Now let's talk about damages. Now under the charter, oh yeah, government, you violated my freedom. Heck yeah, court says, heck yeah, you did. And now the government gets to say, yeah, but we were justified in doing it. Because, vulnerable teenagers, or it's hate speech and people can't be subject to hate speech because we all know nobody gets mad and nobody goes out of line and there aren't some unbalanced people out there. So we actually have to lose our right to have freedom of expression because of the odd nut bar out there, because we're just all little snowflakes that are going to melt and somehow our society is going to collapse, despite 1,200 years of wisdom saying the opposite is the case. So are we better off with our Constitution or worse off? Before we had these rights, without a justification clause. You see, and we're trained, no, but for sure we can enforce these against government. The charter only applies against government. It doesn't apply against regular people. Whereas our common law, really, we would use it against regular people. We would also challenge legislation saying, no, this violates our freedom of expression, but it wasn't as clear, right? But then the government wasn't so activist before. So it's complicated, Payman.
I take it that everybody born after 1982 is not being taught what you just told me about, 1,000 years of precedent.
Well, I was born well before 1982, and I wasn't taught it either. Like my point earlier at the beginning of the podcast is nobody on this watching this podcast, either live or taped, will have read our Constitution. Not a single one.
That's actually sort of my other question that I had. Is 1982 sort of an inflection point, or was it everything was already falling apart by then?
What was falling apart in 1980? What was falling apart?
I don't know.
I didn't know anything was falling apart in 1982. I was about to make some really bad personal decisions, but that has nothing to do with our Constitution. So what was falling apart?
No, I meant like this transition. So was it like overnight that the charter is introduced in 82 and then we get bang activist judges, or were these activist judges clamoring for Pierre Elliott Trudeau to bring in?
No, not at all. Not at all. So I mean, we get this charter. And now the courts do what the courts have to do. Now they have cases in front of them. We've got this Constitution. There's no ambiguity that any government law that conflicts with any rights in the charter. So, I mean, that is clear. You've got this new avenue, this constitutional avenue, and everyone's excited. Like the courts are excited. At the beginning, boy, we had under the initial charter decisions on freedom of expression, just to use it, carry on with that example. Boy, we had strong decisions. Like, the first real court case I had with freedom of expression would have been around 1996, 1997. Boy, did we ever have good case law. Like, it'd be hard to lose. It'd be hard to lose on freedom of expression against a law that really was restricting freedom. Like the government would have to really bend over backwards to show good reasons for that. And now, I mean, can you win on a freedom of expression argument against these censorship laws to protect us from hatred? Like, is it possible to win? I mean, maybe it is. We're going to find out. These laws will be challenged. But back in the day, I mean, these laws that we have on censorship would not be introduced in Parliament back in the day.
Well, what about this interpretation? And I guess after this, we can leave the constitutional law questions, but the common law before 82, over 1,000 years, it was more democratic, it was more distributed, so everybody contributed to it, whereas now, post 82, it's more centralized and you have judicial activists.
Well, that's hard to say too. So what the change is when you get a constitutional document, it's crystal clear. Here's how we go after the government, right? I think we're worse off than we were because we still have the common law rights. They're not extinguished. But what happened is, well, we had that right, and there were limitations in the common law. But we didn't have this justification clause. We didn't have this clause that said after a court finds, no, your freedom of expression has been violated, that the government has the right to justify it. And then, too bad, so sad, there's nothing you can do about it. Your right got violated and the court's saying that's okay, it's justified. We didn't have that before. And so what's happened since 1982 is, and I'll have to go into an explanation about how departments of justice are not consistent with a Western liberal democracy. So what happens is, well, now we've introduced a justification clause. And in the past 42 years, that clause has been used to erode our rights. Oh, yeah, your right was violated, but it's justified here. Oh, your right was violated and it was justified here. And your right was violated, but it was justified here. And we have all this now case law where all our different rights, oh, here's where it's justified. Whereas before, your right was either violated or it wasn't. And if it was, well, maybe if there was extenuating circumstances, we're arguing on damages and remedy, that could be relevant. But not that it was okay. It was never okay for your right to be violated. But now it's okay. And we have professional departments of justice, which most people, I love that. We've got a Department of Justice. We have Crown Counsel going after crime. Sorry, I hit the table and I'm shaking. Going after crime. Like, they love Crown lawyers. They hate defense counsel. But the Crown lawyers 100% of the time are in court arguing that it's okay for the government to have violated your rights. I haven't counted how many cases I have, but like probably in the first 10 years of my practice, I had like 1,000 cases under my belt. I was like a high volume legal aid lawyer, criminal case after criminal case. I don't remember. I'm pretty sure there was one constitutional case I had where it was just, if the Supreme Court of Canada has recently come out with a strong charter case spanking the government, then for a short period of time after that, on a really clear case, they might, yeah, your right was violated, right? But they're in court day after day arguing that violating our rights are okay. And what they do internally is, oh, just wait, this counsel is particularly bright, and they get put into units that are specialized in just arguing against our rights. So they're in these special units. So if you're challenged, it's an important right decision, or now you're under this team. In fact, every province passes a law saying you have to give that team notice if you're going to be challenging something. And that it's all they do. Like the defense counsel, that's not all they do. Or the civil lawyers seeking a declaration. I mean, it's just one case. Every other case is different. But now they're against this team that their expertise is arguing that it's okay for the government to take your rights away. And they have unlimited powers. I mean, I remember in one case I had in federal court where the government had restricted access to a treatment for a while. And this treatment would come in the mail. And like, it was life and death. Like, it was a life and death situation. And a whole bunch of people died. And the court had found in criminal proceedings, no, you're acquitted. A whole bunch of people died. Health Canada killed people by restricting access. So we were in court seeking a declaration, just saying, as a constitutional minimum, when the government seizes vital medication, like, oh, we're talking vital, like life and death, like that you rely on, when the government seizes vital medication that you rely on, as a constitutional minimum, surely they should tell you they're taking it. Like, the person's waiting for it in the mail. Their life depends on it. You've seized it. It's vital. You should at least tell them you've taken their property. Like, in that, yeah, you steal any other property you want of the citizens, but as a constitutional minimum, surely court, when like it's life and death, like they're going to die if they don't get this medication. We all know that, the Lord, So surely, as constitutional minimum, you should at least tell people if you seized it so they can figure out what to do. And then the second thing is, we were talking about a regulatory violation that was pretty minor. Like, surely there's got to be somebody they can go to and say, my life depends on this, and they're worried about like this minor regulatory thing. Like, maybe I should be allowed to get it, because most people don't have the resources to go to court. And when it's life and death, you don't have the time to go to court. So even that very small subset of the population that would be wealthy enough to start court proceedings to demand their medication back, even that small subset, which isn't most of us, you're not going to have time in a situation like this. Well, I think, Payman, I had, of the lawyers that would show up in court, about 12 against me. And who knows the team behind them? Like, they have unlimited, it seems to be unlimited resources. One expert alone they hired, and we lost that case, and they were wanting us to pay for this one expert cost $250,000. Well, like, what plaintiff has that type of money to hire experts that charge $250,000? Like, and then you don't even want to start something, because if you lose, you're destroyed financially. Like, there's no rule of law. Like, rule of law is where the Crown is responsible, the same law as you and I are responsible to. But the Department of Justice, if we had rule of law, what the Department of Justice would do on any rights case is, okay, what's the real issue here to be determined between the king and the citizen? Let's admit everything else. Let's just streamline it, and let's get into court on that issue in a fair way, where we're not overwhelming you with expert after expert that you could never afford. But that never happens. In fact, lawyers will agree with me. It's like they have a playbook where they bring motion after motion, and they just flood you, and they exhaust you financially, and they exhaust you emotionally, and they exhaust you spiritually. I don't have a single client that's gone against the government that would ever even think of doing it again. We don't have rule of law, and it's the Department of Justice. And their recent creations, when the government needed lawyers before, they would just hire private lawyers. But the Department of Justice we're in an adversarial system, and they develop, it's true, their client is the king. And they are in an adversarial system to win for the king. They're not acting for the citizen. So, all the people that love departments of justice, they're acting for the king. And when we're dealing with rights, they're acting against you, the citizen. And they're this huge machine. When I was practicing legal aid at the beginning of my career, your average case, including, where you're arguing charter rights. So, you pick up a file before the first appearance. You got to make a whole bunch of court appearances, and you got to get disclosure, and you got to figure out what to do, and do your legal research, and set it down for trial, and then prepare for trial, and then run. And most would only take a day of trial. Do you know you got paid $540 for that entire process? You could hardly keep your lights on. But the Crown guys, they're getting $250,000 a year, and you pick up the phone and the police do whatever they want. And it's so unfair that it's amazing we have any rights. People owe such debts of gratitude to the defense counsel. One case that it still bugs me, so I use it as an example. And this is before marijuana became legal. There was this young married couple, late 20s. And, and I don't want to shock your audience, but the police came to believe they had a small amount of marijuana for personal use. And so please don't judge them as terrible demons or anything like that. But the police came to believe that they had a small amount of marijuana for personal use. Well, that's illegal, right? So, and it's such a heinous crime that a married couple might have some cannabis in their house for personal use. So this couple wakes up, probably it's like 1 a.m, 2 a.m, to the police turning the bedroom light on. So they wake up to the bed being surrounded with the masked police and machine guns pointed at them, and all in black, all that bullshit. We should never allow in a free society any police officer to be masked, ever. Like how did we get there? When I was younger, that didn't exist. But they're surrounded by all these masked police officers, and the husband says, "My wife's naked.
Oh, man.
Let me slip out of bed, get her some clothes so she can get dressed." Now, we all know that is unacceptable for officer safety, with all these guys with machine guns pointed at the bed, surrounding the bed. So they rip the blankets off. She's embarrassed as can be. She's probably still taking counseling to this day. She was so just shocked by the whole thing, but that just was the icing on the cake. And I had to endure the Crown Counsel arguing that was justified. That's horseshit.
Man, yeah, I have one of my best friends. He's a defense attorney, and his clients, most of them are guilty of sin. They're like drug dealers, and but their rights are constantly getting abused by the government, the police, and they come to him and they're like, what can we do? What's a remedy? And he's like, you have no remedy. There's nothing you can do. Don't even bother.
It's interesting because I was a law and order guy, not interested in criminal law at all. And they force you to take criminal law in the first year of law school. Like you have no choice. And and I learned, like, wait a second, like defense counsel, they're there to actually make sure that the state follows the law. And there's, like this reasonable doubt thing, like it protects all, like we learned from experience, right? And remember, we used to kill everyone, right? So and I was just so attracted to the role of actually holding the state to account in the process, because it's adversarial. It's very adversarial. And what's interesting is, and what you said just totally brought it to life. What surprised me is I've had cases where I really believed my client was innocent and they get convicted. And, I'm grieving that, but I could at least see in the circumstances why the court thought they were guilty, right? So I'm grieving that somebody I thought was innocent was convicted. And that bothered me. But what surprised me is what I found is people that, we call them frequent flyers. So they're in and out of the court system. And, there's a subset of young men that until the frontal lobe develops in their mid-20s, like they're just a nuisance, and then they grow up and they go away, right? And then there's just some people that have so much trauma in their lives, and then you have the a smaller subset of sociopaths, and it takes the system a while to figure out who those people are. But but I would have people that were frequent flyers, like nuisances, but they would get convicted on evidence that nobody should get convicted on because the court knew where they were, and that bothered me more. They're guilty, but they're getting convicted on evidence nobody should be convicted on. That bothered me more than, when I have somebody, they're innocent and they're convicted, but I could at least see why the court was there, right? So, yeah, we have problems. We have problems.
Shawn, any chance we could get you to run for a position of Minister of Justice?
No. Yeah, no, I see, because I wouldn't want to be subject to a party whip. And there again, we have another structural problem. Is our Attorney General, the person that, dictates to the police what our policing and priorities are, is adversarial to the citizen, represents the king, not the citizen. And the Department of Justice lawyers represent the king, not the citizen. And so Minister of Justice is a problem. We can't have the government determining the police priorities and directing this Department of Justice, which we shouldn't have. Like, the system is designed against the citizen. And the fact that the government gets to appoint the judges and is responsible for paying the judges, the whole thing is stacked against the citizen. So the whole system. So we shouldn't have a Minister of Justice. I'm not sure what the answer is on the other side, but it's going to be different.
Shawn, how are we doing for time? We're at the 58-minute mark.
I can go a little longer. I mean,
all right. So
I'm enjoying the conversation.
No, this is not where I thought we were going, but this is amazing. It's like an educational session. What is the Shawn Buckley solution then? Should people, is it like sheriffs? The people elect the sheriffs and they tell the sheriffs how to run the department?
I actually hadn't really thought of that. Like, for sure, we got to get rid of the departments of justice and just have the government hiring lawyers as need be to do things, and definitely in the criminal law sphere. So, if I'm acting as the, crown on a file, because you got to have then just the people that do criminal law in a pool and they rotate. Okay, this file your crown, that file your defense. We have to have it structured so that there's equal resources, because you can't, or we have to get out of an adversarial system. and go to more of an inquiry system like they have in Europe. But you can't have an adversarial system where one side of the equation has 95% of the resources by design. Like, that's silliness. And you can't have a group of lawyers that are invested, because we get invested in our clients. We get a mindset. Like, the police end up doing this now and again. Every now and again, they have to give their heads a shake because they get too, and especially on serious crime, there's a tendency to draw a conclusion too soon. And then the tragedy is they're not still looking and they got the wrong guy, right? So every now and again, they do a reset. And then as defense counsel, I would understand, oh no, I'm getting too biased here. Well, it happens in the Crown Counsel office, but it's institutionalized because you spend your whole career there. And it's us against them, and our client is the king. And no, we can't go there. So criminal law, no. Hey, if I'm crowned this week and I get a request from another lawyer for fair disclosure, meaning give me everything that's relevant in the police file, and I know I'm writing that guy a letter next week when I'm defense counsel and he's crowned, I'm going to be fair. I'm not invested against the citizen because I'm acting for both the citizen and the state, right? Like, there's simple ways that we can make this way easier and still be in this adversarial system. But we have to be asking, well, where does the power lie? and it can't be tilted to the state against the citizen. I haven't spent a lot of time thinking about what the answer is, Payman, but we'll be able to come up with solutions. We just have to accept we have a problem first.
No, that's right. Shawn, I just want to go to some questions from the audience. Somebody was asking about the Oakes test. Ask him if the Oakes test is still used. If you could just briefly explain what it is for the audience.
So remember that Section 1 justification clause? So, charter guarantees our rights. Great. Subject only to such reasonable limits prescribed by law. The Oakes test, Oakes was a defendant, and it's one of the first Supreme Court of Canada cases going, well, how does the government bring a justification argument? What does this mean? So it actually sets out specific things for the government to succeed on a Section 1 argument. So, it's got to be prescribed by law. So there's actually got to be a law or a regulation. Well, what is that? It's got to be proportional under, so yeah, I can take away your right, but the court will ask the question, well, okay, well, you violated that right and it's prescribed by law, but was that proportional? Like, let's say, you killed somebody over a speeding violation. No, that's probably not proportional, right? So there's a weighing so that, well, you can't justify it if, you're way over the top. And then, are you restricting the right in the least restrictive way? So, early on, the courts would ask the question, well, okay, you're restricting the right. You're doing it by this legal mechanism. It's prescribed by law. But, is that the least intrusion on the right that you could do for this great public purpose that, you've identified? Because it's got to be reasonably justified. So they've got to say, well, here's the mischief we're trying to solve that necessitated violating the rights. But the third part of the test is are you doing it in the least restrictive way? So, yeah, no, that still applies, but there's been subsequent cases, and it's definitely not, before it used to be almost impossible. Like when Oakes first came out, it was really tough for the Crown to get a justification under Section 1. And now I would say it's really hard for the defense to resist the Crown succeeding under Section 1. So things have changed, but it's still part of our law, the Oakes decision.
All right, there you go, Patrick. You got your answer. I think I saw another question. It was regarding allodial title. Payman asked Shawn about allodial title and how it plays into English common law.
Oh, I'm drawing a blank.
Sorry, Wolf, you didn't get a good answer.
No, yeah, and I'm sorry. I'm sorry. It's the word allodial that's throwing me off. But I can say that the king owns all of our property. So, if you buy your house and you pay off your mortgage and you get a state of title certificate, it will say that you have a fee simple. And what that means is that the king who owns your property has granted you a fee, so has granted you permission to use the property, and there's no conditions. So simple. It's just, hey, you have this grant to use my property, the king, because it's the king's property, and the king isn't putting any restrictions on it. And so we pretend and act, and for most of us, as we interact with each other, it is as if we do own the property. But, fail to pay your municipal property taxes, for example, and see how long you own your property.
Could you apply that same argument to the US? They have property rights, but if they don't pay their tax, their property can
And
get
you see,
seized.
that's a problem. And it's not everywhere. Like some countries, they're few and far between. The state can't take your property. They can't sell your property, right? Which is a different issue than them being able to put a charge on your property. But even that raises rights issues. So, but I'm by no means an expert in property law, nor do I pretend to be.
I think that's it. You got a lot of praise. Prairie says I could listen to Shawn for hours. I think that's the last question, though. I could listen to Mr. Buckley all day. It's a common theme.
Right. Well, sadly, I don't have all day, but I'm happy to come back one of these days. So,
all right. I guess we could end it there. I'm sorry to the audience we didn't get to the NCI. But Shawn, do you want to do a plug for anything yourself, the NHPPA, the NCI?
Well, yeah, actually, I'd like to do a plug for both. So, I put in my caption here, nhppa.org, and that the NHPPA is a nonprofit that we're trying to protect your health rights with particular emphasis on natural health products. Go to our website and subscribe to our email. And I think we only send out about 6 emails a day. No, I'm just kidding. Like, it's not even weekly, I don't think. So we're not going to flood you, but it's that, and following the social media channels is how we alert you to things. So like in the last 2 weeks, there was a bill in the Standing Committee of Health that was really important to our industry. It was a private member's bill that actually got into committee. Like, maybe that's happened 10 times in the last 140 years. And at the last minute, there was a whole bunch of amendments that would have gutted it. And so the NHPPA managed to get 500,000 e-letters sent to 12 different politicians, and we stopped it. But if you weren't on our list, we couldn't have let you know, right? And this is important. Like, so go there and get on our list. And then NCI payment, we still have the problem where there's confusion, right? Because we lost control over our old social media channels. So, I mean, you would have helped build those. You had Clipper teams, and we had all of this stuff happening. So, like, I run into people going, "What? You're still holding hearings?" Like, we just had these hearings in October that were just like, I don't even know how to describe them. Like, we changed the topic to "Are Children Safe in Canada?" And I wasn't ready for it. Like, you're going to be upset. You're not going to know what to do with that set of hearings. Like, I used to say, you watch a day of the NCI, you're not the same. And you got to watch the whole day, gaffes and all. Like, don't do it per witness. Watch the whole day hearing. But I don't know what to do with it. It's just, and a lot of people don't know what to do with it. It's just too crazy. Well, a lot of people don't even know that because if you're following the old social media channels, well, there's no way they're going to have anything that I'm involved with, right? So we're holding roundtable. We had a roundtable, like, it really trended outside of the NCI circles we had Byron Bridle, we had Jessica Rose, and who was the Byron Bridle, Jessica Rose? Who was the third one? It was a hilarious one because, Dr. Sabine Hazan. Well, they all got so engrossed in what they were talking about. You could see like one would be talking and the other two, they're like, oh, I want to jump in. And the conversation was just mind blowing, right? So go to nationalcitizensinquiry.ca. We don't care if you follow the old ones, but also follow the new ones. So at least you know what we're doing, right? So, and we're planning on having continuing hearings in the Edmonton area in March on the same topic. So, but if you haven't seen the Vancouver ones in 2024, pretty crazy, pretty crazy. And they're having a bit of a financial crunch. So, now would be a good time to support them. They're doing good work. So I'm
Well,
not
you
in
heard it.
administration anymore. I'm lead counsel, so I, jump in and prepare witnesses and that. But I'm just too busy and exhausted to be in the administration stuff. I've got to focus on the NHPPA part.
Yeah, I remember you always spread yourself too thin. So everybody, you heard him. Go to nhppa.org, sign up, donate. Go to the nationalcitizensinquiry.ca.
Yeah, and like I say, we don't care if you follow the old ones, but it's just you're not going to hear about the new hearings, and you're not going to hear about the roundtables and stuff like that. And it's just, I challenge anyone to just pick any day of the October hearings and watch the day, and you won't know what to
Let's
do about it.
Shawn, let's do this live. What's your new Twitter handle for the NCI?
Oh heck, I think it's at NCI Canada. Like you'd have to go. I think they're all at NCI Canada, right? So we basically rebranded because when we when we started the social media accounts, like we had one volunteer do it, and then some other accounts would be set up, and then we got the contractor to kind of manage them all. So and then like the whole country basically like jumped in and helped us push it, because remember we were slow out of the gate on communications because we're just volunteers. So until Teresa kind of picked it up and started managing it, and then people like you jumped in. And so what really hurts me is you take them but you don't let people know. We all built it together, and the intention was for the NCI and holding hearings and that. So when they don't post about the new hearings or roundtables we have with witnesses, it just makes me sad. That's all.
Well, try to focus on the positive, Shawn. We need you in this fight. Don't die on us.
Well, and like I say, I mean, yeah, and I am positive. Like things happen, and we have to accept it. And and we reasonable people can disagree. But I'm pretty excited about what potentially could be happening on a narrative change because of the election south of the border. Like if Mr. Kennedy is allowed to, start kind of bringing truthful information out. I mean, Jay Bhattacharya as the director of the National Institute of Health. Can I just share a funny NCI story with Jay Bhattacharya? So I was calling him as a witness virtually at the Winnipeg hearings. So he wasn't able to come out in person, just the schedule wouldn't allow it. So he's testifying at Winnipeg. Payman, it's the only day we have the mainstream media show up. We have CBC in the room filming while Jay Bhattacharya is testifying. And we've got this big screen, and Jay's up on the screen, and actually in the CBC footage that they broadcast on CBC locally in Winnipeg, Jay Bhattacharya is on the screen. Do you know what he's talking about while they're filming? Being censored by the CBC. Like, you can't make this stuff up. It's hilarious. So I'm really hopeful.
Well, yeah, I think they're going to turn for the better now with Trump, and I don't know. It's just I see light at the end of the tunnel.
I see there to be an opportunity, and we're in an information war. And let's just go back to COVID because we were talking about the NCI. When the NCI was running in 2023, you couldn't talk to your family member or neighbor about it. You can now. You can. They'll listen. Like my wife's a realtor, and if any client or she likes to make mischief too, but what she's noticed has changed is, anyone's she'll like, if people are talking about people that are around them being sick, she'll just says, yeah, it's the vaccine. And now most people just agree with her. Like, people know, like, it's out there. And if they don't know, you can tell them and get them watching the NCI. Like, it'll change their minds, right? But we're in information war, and we're still jabbing kids. And we really have to stop that. We have to stop jabbing kids, and we only will if we force the narrative to change. Why are we waiting?
Shawn, I wanted to thank you very much for coming on. I had a blast. I love these information sessions, and I'm sure the audience appreciated everything you had to say. So thank you very much.
Yeah, it was fun. Thanks, Payman, and thanks, everyone.
Shawn, I'm just going to hold you over until after the stream, but otherwise, have a nice day, everyone.